Jacinda Ardern.
Thank you, Mr Speaker. It's my pleasure as a member of the Regulations Review Committee to stand and speak to the Statutes Amendment Bill. And my first experience with working with such omnibus bills, which are obviously a practice of this House to be introduced as a means of correcting areas of perhaps anomalies or errors in the law, was when I was a staffer in this place under the last Labor government. And I learnt through that process that it's key when working with such omnibus bills to ensure, well, firstly, that they are non-controversial amendments, and that's required almost by their very nature in the way that the standing orders allows them to be dealt with. But they also that they be widely consulted and that consensus build across the House for the amendments that are contained in that bill. It's certainly my experience as a staffer having to consult with a wide range of parties and those interested across from both sides of the House, that it's in the interests of this Parliament and this House to make sure that they are non-controversial and fall within the correct criteria, the scope of the way standing orders intends for those omnibus bills to be treated and the kinds of amendments that should be contained within it. So I do think that we need to assess this Statutes Amendment Bill number 2 with that in mind, and I thought it might be useful again to review what the kind of criteria that the standing orders expects this House to keep in mind when deciding whether or not we are looking at non-controversial and non-contentious policy changes. And as I think my colleague Leanne Dalziel have already pointed out, those criteria set across in 258 of the standing orders 1F, which state that statutes amendment bills can consist entirely of amendments to acts, so they therefore must be an omnibus bill. And then again we see in 295 probably the true reason why they need to be non-controversial, as it states in 295(2), if any member objects to a clause standing part of a statutes amendment bill or of a bill that was formerly part of a statutes amendment bill, the clause is struck out of the bill. So I think that probably it's a very pragmatic reason why those amendments do need to be non-controversial and not substantive when it comes to a policy change. Keeping that in mind, I think that the opposition is right to point out those areas where we will be looking for further explanation and further exploration of various elements of this bill, because I do think that some of them, as Charles Chauvel has pointed out, do border on the substantive side. And I think, though, that it's right that Labor has decided to support the amendments contained in the bill, but we are reserving the right to reconsider any of those individual amendments once they do reach Select Committee and, of course, again in the Committee of the whole House, and reserve the right to withdraw support from those amendments. I think just to touch on again, and I noted that the last speaker from the Māori Party did touch on the definition of the foreshore in the National Parks Act 1980. I think given the current debate that's going on around the future of the foreshore and seabed legislation, it is pertinent that we point out again that this could well have ramifications for that, and it's very important that the Select Committee consider that when it looks at that particular amendment. Currently, the National Parks Act refers to the definition contained in the Harbours Act 1950, which has been repealed, and the new definition is that any land covered and uncovered by the flow and ebb of the tide at mean spring tides. And we've expressed concern with our previous speakers that will have unintended consequences in light of the Foreshore and Seabed Act. Now, I note that we have been given some reassurances by the Associate Justice and by the Attorney General that it won't have a direct effect, but given that this is a period of fluid policy discussion, I think it's important we flag that we'll be reserving our right to reconsider that at this point. I think there's also already been some discussion around the amendment to Section 9 of the Birth, Deaths and Marriages Registration Act, which I just want to touch on briefly again. Again, questionable as to whether or not this is bordering on a substantive policy change, given that it allows that when a parent is allows a parent to be unavailable in the signing of a birth registration form. And although it may well be a sensible amendment, again, questionable as to whether or not it is substantive and in fact a policy change of sorts. We've also touched on, I think, some of the amendments to the Conservation Act, which we'd also like to look a little more closely at Select Committee. There are several other concerns which have been raised in the Juries Amendment Act, the Marriage Act 1955, the Property Law Act, the Protection of Personal and Property Rights Act, and also the Building Act, which I'm pleased that my colleague Charles Chauvel has raised, I think quite rightly, in the spirit of the way that statute amendment bills work in this House, has raised them directly with the Minister with responsibility for this bill, because it is in good faith that we operate on these bills, and it is very important, I think, that we maintain the conventions of this House in the way that we deal with statute amendment bills. There are also a further 38 acts which are to be amended by this bill, which we have no objection to. Some of my colleagues may have already touched on that, but I think it's important to point out that although there are a few we're highlighting, there are in fact 38 which we see no issue with. I'm pleased then, Mr. Speaker, to continue to be involved as a member also of both Regs Review and also Justice and Electoral, and the further consideration of the Statutes Amendment Bill. And I'm pleased so far at the open discussion that's occurred on some of the areas where we have concerns. I'd hope that both sides of this House continue to act in good faith as we consider how best to progress matters in this bill which are non-contentious and those which may, in fact, on further examination prove to be.